Today we will start with a new topic in civics, our criminal justice system. You will find this on page B102, a criminal justice system. Okay, now one of the most important functions of the government is to maintain peace and order and harmony in the country and society. Because if we want prosperity and development and growth of an individual as well as society or a country or a nation, then peace is required for all that. Without peace and harmony and order, all this cannot be achieved. And so this law and order, peace and harmony in the society, it is maintained by the police and the law courts. So in this particular chapter we'll see that how our criminal justice system works. If you remember, in the last chapter we studied about two types of cases: civil cases and criminal cases. Do you remember anything about it?
Yes, ma'am.
Okay, so can you tell me, do you remember what were civil cases? Anyone? What were civil cases and what were yes, beta.
Civil cases are, ma'am, taking away one's right, ma'am, in matter relating to, ma'am, property, house rent, ma'am,
Mm-hmm.
ma'am, purchase and marriage, ma'am, divorce, and ma'am,
Okay.
uh,
Criminal cases?
Ma'am,
Yes.
cases relating to
Yes,
ma'am
Rishti.
cases ma'am cases relating to accident, dacoity, and murder.
Okay.
theft, murder.
Okay, so murder, kidnapping, robbery, dacoity, fraud, rape, all these fall under criminal cases. Now, in a criminal case, a person breaks a crime. He does something against the law. So, he is doing a crime, and this he does by breaking a law. So, now the way a case proceeds for a civil case is very different from the way it proceeds for a criminal case. Now, in a civil case, there are two parties, and one party files a case against the other. But in criminal case, the procedure is not like that. In a criminal case, it is that a person who has been harmed or who is the victim, he goes to the police station to file the FIR, and then after filing the FIR, the police starts the investigation and they present the case in the court of a magistrates. Alright, so the procedure through which a criminal case proceeds and a civil case proceeds is very different, and in this chapter we will have a look at our criminal justice system, or the way cases proceed in or criminal cases proceed in our judicial system. So, and to for a better understanding, now it has been given in the form of a story so that we can able to understand that how the case proceeds for a criminal case. Now this is the story of 16th May 2004, and Sohan Singh, he goes to the house of Ramesh Sharma and he wants his 10,000 rupees back which he has given to Ramesh Sharma 3 years ago. So he goes to him, says that this is my fifth visit to you and when will you return my money? And Ramesh Sharma is like, what money you are talking about? And I never took any money from you, and you are telling a lie. And Sohan Singh, he is taken aback and he says that how can you speak like that? And when we were at good terms, I lent you money just like that, and now you are saying all that to me. But Ramesh Sharma, he said that what is the proof that I took money from you, and I don't owe you any single paisa. Now you go away, get away from here, get lost, and do whatever you want to do, but I have not taken any money from you. So Sohan Singh says, okay, then I will teach you a lesson and you will regret that you have done like this. And so on 20th May 2004, Sohan Singh, he goes to the house of Mr. Ramesh Sharma with two men who were armed with lathis. Okay, and as Mr. Sharma, he comes out of his house, so Sohan Singh and the two men with him, they beat him with lathis and he falls on the ground, becomes unconscious, and he is also bleeding a lot. So then Mr. Sharma, he goes to a hospital, and the doctor, he examines him, he ties a bandage on his head, and he also gives him an injury report as to what injury he has sustained. Then Mr. Ramesh Sharma, he goes to the police station, and he says to the police officer on in charge on duty, he says that, sir, I have come here to file an FIR. What is an FIR, by the way? Anyone knows what is an FIR full form?
First,
First
first
information
information
report.
Okay, first information report of a crime that has been committed. So he says that I have come to file an FIR, and Sohan Singh and his two accomplices, those who were involved with him in the crime, they hit me with lathis, and they injured me. And here is the report of the doctor. And so the very next day, that is 21st May 2004, a police team which were led by Sub Inspector uh, Chaudhary, they visit Sohan Singh's house, and he is arrested. And the police, while arresting him, tells that you have hit Mr. Ramesh Sharma, and you have injured him. And now, where are the two men who were with you in this crime? And take us to their houses. And so, you know, that means Sohan Singh and the two people with him, they are arrested. And after 24 hours, the police, they present Mr. Sohan Singh in the court of a magistrates, and it says that, sir, the accused here, he beat Mr. Sharma with lathis, and he injured his head, and we need him in custody for 14 more days, so that we can collect evidences against him, we can go to the scene of the crime, and we can try to get the weapon of offense and all that. And so the judge, he said that, okay, accused is to be kept in police custody for 14 more days. Okay, now during then 5th June 2004, the police, they file a charge sheet in the magistrates court. Now charge sheet is a paper containing all the charges that are against the accused, means what wrong he has done. So it is mentioned there, and it also contains the statements of the witnesses also. And so the court, it also gives a copy of this charge sheet to Mr. Sohan Singh. And so Mr. Singh, that means now the case has gone to the court, it has not remained with the police, because the police has already filed a charge sheet in the magistrates court. So Mr. Sohan Singh, he tells the court that he cannot afford a lawyer, and so the magistrate, they appoint Raman Pandey as Sohan Singh's advocate, and that is defense lawyer, and this also at the government's expenditure, because according to the article 22 of our constitution, every person has a fundamental right to be defended by a legal practitioner of law or by a lawyer advocate. And article 39A, it says that it is the duty of the state or the government that if a person is poor and under other circumstances, if he is not able to provide for himself a lawyer, then the state has to provide the person with a lawyer at the charges of the state or the government, on behalf of the government. Okay, means from the government side. So 12th June 2004, after 14 days in police custody, the accused, means Mr. Sohan Singh, he manages to get bail with the help of their lawyer. And during this time, the police, they have also recovered the lathis, the two lathis also, and the blood stained shirt of Mr. Sharma. And the police, they also recorded the statements of two eyewitnesses. Now the accused, that is Mr. Sohan Singh, he goes to meet Mr. Raman Pandey, that is the defense lawyer who has been given to him to defend himself, to defend Mr. Sohan Singh in the court. And he tells him that, sir, these are my papers, and I have hit Mr. Sharma, but this I did when he threatened me with a pistol, and so I plead not guilty, because whatever I did it in self defense. Okay, and so he meets his defense lawyer also, and now the trial, it begins. So the case begins, and so the case begins on 15th September, and the accused, Mr. Sohan Singh, he says that I plead not guilty. I say that I have not committed the crime because Mr. Sharma, he threatened to kill me with a pistol, and whatever I did it in self defense and out of panic, because I got panicked, and in self defense I have done it, and I claim I want a fair trial. Okay, So now the public prosecutor. Now the public prosecutor, public means government. So the government, the prosecutor or the lawyer who is on behalf of the government, who is presenting a case on behalf of the state or on behalf of the government, because the police is a organization or an institution of the government, and so the public prosecutor, he presents the case on behalf of the victim. So that means he is on side of the victim, and he presents his case now, and he says that, sir, on that particular day, he tells the judge that, sir, on that particular day, Mr. Sharma came out of his house when Mr. Singh, he abused him, and as soon as he came out of his house, Mr. Sohan Singh and the two people with him, they rained lathis on him, and because of that he fell down on the ground. He became unconscious also, and he bleeded a lot also, and the doctor injury report says that he got a 2-inch deep wound in his head. And the investigating officer, the IO, he has also recovered the blood stained shirt of Mr. Sharma, and he has also recorded the statements of two witnesses. And so the judge asked that where is the IO or the investigating officer, and he should present the weapon of offense and the blood stained shirt present. And then he asked that the public prosecutor to present the prosecution witness. And so the IO, the investigating officer, he appears in a box and he hands over the things to the court, that is the blood stained shirt and the lathis. Okay, now and then the public prosecutor, he presents his witnesses, and he asks him that what did you see. So the first one says that, sir, I saw that Mr. Sharma was being beaten by lathis by Mr. Sohan Singh and his men, and then he fell down bleeding. And so the judge hears till here, and he says that okay, the case is adjourned now till further date. Then the defense lawyer, means the lawyer who is on side of the accused, and now he begins to cross examine the witnesses which were put by the public prosecutor, and he says that okay, tell me that how Mr. Sharma, he provoked Mr. Sohan Singh, and that he threatened to kill him with a pistol, and then he asked him that how did you happen to arrive on the scene. So the witness, he says that no, sir, he did not bring out a pistol, and I arrived when I heard the whole noise and the whole commotion, so I came out at that place. But the advocate or the lawyer who is on side of the accused, he says that, but at that time you were working in a field which is so far away from your house, so how did the noise reach so far. So the witness says that no, sir, at that time I was in my house, which is at a stone throw away, means very near to Mr. Sharma's house. Okay, and so that was the first witness. Now the second witness is also cross examined, and he also says that I was also at my house, which is near Mr. Sharma's house, and I also rushed out when I saw the noises, and I saw him that he was being beaten by Mr. Singh and his two men. So the judge, he hears till here, and he says that he further adjourns the case till the next date. And the next day, 25th October 2004, the defense lawyer, now he presents his witness. The public prosecutor, he already presented it to witnesses. So now the defense lawyer, he presents his witness, and he asks him that you tell the court that what did you see that day. So now this witness, he has another story to tell, and he says that, sir, I saw Mr. Sharma holding a gun, holding a pistol, and threatening Mr. Singh, and out of panic, means they got so afraid that Mr. Singh and his men, they ran away, they fled away, and they did not hit him at all. And then the lawyer says that the doctor, he was pressurized to write an injury report, but the public prosecutor, he says, but the doctor injury, it said that he sustained a 2-inch deep injury on his head, and the doctor's report, it cannot be wrong. And so the public prosecutor, he tells the judge that, sir, the defense lawyer, he is telling a lie. And the judge also says that how can you prove that the doctor's report is wrong? And the blood-stained shirt, it shows that assault has taken place, because the defense witness said that they did not hit him and they fled away. But the blood-stained shirt was there and the lathis were there, so he said that the blood-stained shirt, it proves that there was an assault. And so he then again adjourns the court till the next date. And then on 8th November 2004, the judge, he says that since the public prosecutor, he was able to present witnesses also and evidences also, and weapons of offense also, and then the bloodstained shirt also, so he was able to prove beyond doubt that Mr. Singh, he is guilty. And so the judge, he pronounces judgment, and he says that taking all the things into account, the injury report, the recovery of the weapon of offense, testimony of the witnesses and other evidences, the court, it holds Mr. Singh guilty of assault and also causing a grievous injury to Mr. Sharma, and because of which he could have died also, because the injury was in his head, and that also a 2-inch deep injury. And so he gives him the punishment, says that a punishment of 1 year simple imprisonment and a fine of 5,000 rupees. And then he tells Mr. Sohan Singh that if he wants, he can file a separate case in the civil law for the recovery of his money. So that is how a criminal case proceeds in a court of law. And from the above incident, you can see that there are main four players in the judicial system, in our criminal justice system, that is the police, the defense lawyer, the public prosecutor, and the judge. So now we'll have a look at all four of them in a little detail. First, the role of the police. Now, as in the we have read the story above, the one of the primary functions of the police is to file the FIR, and this is on behalf of the complainant or the victim of the crime. So when a person, he goes to complain about a crime, or he is the victim on which certain crime has been committed, so he goes to the police station, and it is the duty of the police to file the FIR. And after the FIR is filed in, or it is registered, then the police, they begin their investigation. Now the investigation, it includes many things like getting together information regarding under what circumstances the crime took place, means what were the circumstances leading to the crime, what happened so that the crime took place. Then they also visit the police also visit the scene of the crime, and they collect all relevant evidences. Then they recover the weapon of offense also, means the weapon with which the crime has been committed. Then they also record the statement of witnesses. And then on the basis of the initial evidences collected, if the police thinks that the accused is guilty, then he is arrested, and then he or she is produced before a magistrate's court within a period of 24 hours. Then the police, they may ask for extension of the custody for the accused person for a few more days to collect further evidence, and this is normally granted by the judge. Like in this case also, they asked for a further custody of 14 days, which was granted by the judge. Now on the basis of the investigation into the various aspects of the crime, the police, they have to file a charge sheet in the court within a maximum period of 3 months. So within a period of 3 months, the police, they have to file a charge sheet. They have to present a sheet containing, or a paper containing, all the charges against the accused in the magistrate's court, and this they have to do within a maximum period of 3 months. Now trial in the court, it takes place on the basis of this charge sheet, and now it is not the duty of the police to judge and to decide whether the person is guilty or innocent. Now that is the work or the duty of the judge to decide. Now as we already know that there's a rule of law. Now rule of law means that everyone is equal before the law and no one is above the law. Now what that means is, even the police and the courts, while they are investigating the case, they also have to function according to the law, and the police, they have to conduct this investigation according to the law. And the police, they also have to respect the fundamental rights and the human rights of even the accused person. So though the person, he is accused, but still he is not proven guilty, and even an accused person also, he also has his fundamental rights and human rights. And so, according to that, the police is not allowed to torture, beat, or threaten the accused or the victim or the witnesses during the investigation process. And the police, they cannot even give any punishment to any person for any wrong that they have done, whether the wrong is small or big, means whether what they have done is very minor or major. Still, the police, they cannot give punishment to anyone, and that is the work of the judge to award punishment. Now, the Supreme Court, they have also given certain guidelines for the police to follow during arrest or detaining or interrogation of any accused person. And the Article 22 of our Constitution, it guarantees the following fundamental rights to a citizen: that no a person who is arrested, he cannot be detained in custody without being informed of his crime, that why he's being arrested. So a person, when he's being arrested and he's being detained in custody, he need to be told that on what basis he is being arrested. Then even a arrested person, a person who is arrested, he cannot be denied to consult an advocate or a lawyer of his or her choice. And every person who is arrested and who is detained in custody, the person has to be produced before a magistrate's court within a period of 24 hours. And this is not the time, it excludes, means the time included for the journey from the place of arrest to the court, that is not included in that. But however, a person who is arrested and detained under laws which provide for preventive detention, now in that case a person can be imprisoned without a trial for a period of 3 months. Now the Criminal Procedure Code, it guarantees following rights to an arrested person also: that the arrested person, he has a right that no one can ill-treat him or torture him during arrest or in custody. Then whatever confessions are made by the arrested person or the accused in police custody, they cannot be used as evidences against him in the court, means they can only be brought to the notice of a court, and they can be used as a plea to ask for further time in custody or for further custody. But whatever a person confesses in custody in a police station, now that cannot be used as evidence against him in the court of law. Then boys under 15 years and women of all ages, they cannot be called to the police station just for questioning. Okay, so these were some of the rules. Now, how to file an FIR, or the First Information Report. Now, FIR is the short or the abbreviated form of First Information Report, and it is the first-hand information of a crime or an incident recorded by the police officer on duty at the nearest police station. And on the basis of the FIR, the police, they start the investigation. Now, an FIR, it can be launched by the victim or any person on his behalf, or even by an eyewitness of the incident of the crime. And the law, it says that it is compulsory for the officer in charge of a police station to register an FIR whenever a person comes to give information about a crime. And this information can be given to the police orally or in writing also. And an FIR is usually filed in the police station of the concerned area in whose jurisdiction the offence, means an FIR is usually filed in the police station under whose jurisdiction the crime has been committed. And in the FIR, the date, the time and the place of the offence is mentioned. Then some basic details about the offence and the description how the whole thing occurred. And if you know the name of the accused, if you have a person whom you think has committed a crime, so his name and address of the accused person, and about his identity, and also the name and address of the person who is filing a complaint, all that need to be there in the FIR. And there is a particular format in which the police, they register an FIR, and then it is signed by the complainant or a person who goes to file a complaint. His signature is also there on the FIR. Now, although an FIR is to be launched only at the police station, which has the jurisdiction to do so. That is means the police station under whose area of authority the crime has been committed, and usually it is the nearest police station. But a situation may arise where the nearest police station, it may not have the jurisdiction over the area. Means sometimes the nearest police station is something is different from the police station under whose jurisdiction the crime has been committed, but it is it is nearest to you. And so you can even go to file the FIR in that police station also, because according to a judgment given by the court in 1999, Satvinder Kaur versus Government of NCT of Delhi 1999, this cannot be the ground to refuse the filing of the or the registration of an FIR. Means the police personnel, they cannot say that no, since the crime has not been committed in under our jurisdiction, so we will not file the FIR. They cannot do so. And why? Because if they do so, then there would be a delay in the collection of evidences and investigation by the police, because till the time the FIR is filed in, the police, they don't start the investigation. And if the police station, they go on saying that no, this crime has not been committed under jurisdiction, we will not file the FIR and all that, then there would be a delay. And the court, they stated that the officer in charge at the nearest police station, he is obliged, he is under the law to file the FIR, and then the matter can later on be transferred to the concerned police station. Okay, the Supreme Court, it has ruled under section 154 of the Criminal Procedure Code that the police have no choice but they have to file the FIR, and the complainant, mean the person who goes to file the complaint, he has a legal right to get a free copy of the FIR from the police. And if the SHO or the station house officer, he refuses, if the police officer on duty, he refuses to file the FIR, then the complainant, he can approach the senior most police officer of that area, who is usually the superintendent of police or the deputy commissioner of police. And if this police officer, means the superintendent of police and the deputy commissioner of police, they also refuse to file the FIR, then the aggrieved person, the person on whom this particular crime has been committed, he can also go directly to the magistrate's court and file an FIR under section 156(3) of the Criminal Procedure Code, and the court, then they will appoint an investigating officer to examine the case and collect the evidence. Okay, we'll come back to that green box which we left, and let's have a look at that also. There was a series of complaints regarding the ill treatment by the police, that the Supreme Court had given down certain requirements and procedures that the police and the other agencies, they have to follow regarding the arrest, detention and interrogation of any person, and these are known as the DK Basu Guidelines. Now some of the points included in the DK Basu Guidelines are that the police officials who go on to carry the investigation and the arrest and the interrogation, now they should wear their clear name tags along with their designation. It should also be visible, it should be clearly visible to the person, to the other person there. Then a memo or a memorandum of arrest, it should also be prepared at the time of arrest, and it should have the time and date of arrest of the person, and this memorandum should be signed by at least one witness, and then it also needs to be signed by the accused person, the person who is accused of being committing this crime. Then the person who is arrested or detained or being interrogated, he has a right to inform a relative, a friend or a well-wisher about that he is being taken into detention, or he is being taken into custody or being arrested. Now if the person does not have any of his well-wisher or friend or relative living with him, then it is the duty of the police that they have to tell the time, the day, place of arrest and the venue where the person is being kept for custody to a friend or a well-wisher within 8 to 12 hours. Okay, so have you understood till here?
Yes, ma'am.
Everything clear? Any confusion anywhere? Yes, what about the rest of you? Srishti? Adya?
No, ma'am.
Okay.
No, ma'am.
All right. So we'll stop here for today.